Pennsylvania has a moderately regulated breaking lease framework where the state-level rules provide a foundation, but local ordinances in Philadelphia and Pittsburgh add significant complexity. The governing law includes the Pennsylvania Landlord and Tenant Act of 1951, found in Title 68, along with general contract principles, and, for Philadelphia properties, the Philadelphia Fair Practices Ordinance and local tenant protections. If you're a landlord or tenant in Pennsylvania, what rules apply depends partly on where your property is located. Let's start with the landlord's duty to mitigate damages. Pennsylvania law requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. This duty has been clearly established through Pennsylvania case law, most notably the landmark Pennsylvania Supreme Court decision that confirmed landlords cannot simply sit idle and collect the full remaining rent from a departing tenant. The landlord must take reasonable steps to find a replacement tenant, advertising the unit, showing it to prospective tenants, and accepting a qualified applicant. The landlord is not required to give the vacated unit priority over other available units or to lower the rent below market rate. But the landlord must make the same reasonable effort they would make to fill any other vacancy. If the landlord re-rents the unit, the departing tenant's liability is limited to rent for the vacancy period, plus the landlord's reasonable re-rental costs, advertising, cleaning, make-ready work, and leasing expenses. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable mitigation. Pennsylvania's mitigation duty is based on case law rather than a detailed statute, which means the standard of what constitutes reasonable efforts is developed through court decisions rather than a specific statutory framework. Courts evaluate reasonableness based on the local market, the property's condition, the landlord's typical practices, and whether the landlord treated the vacancy the same way they would treat any other. Early termination clauses are generally enforceable in Pennsylvania. The state does not have a specific statute capping early termination fees. Pennsylvania courts enforce reasonable contractual provisions, and a clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and defensible. The fee must represent a reasonable pre-estimate of the landlord's anticipated damages. A grossly excessive fee could be challenged as an unenforceable penalty. Pennsylvania's Unfair Trade Practices and Consumer Protection Law provides a basis for challenging lease provisions that are deceptive or unfair, including early termination fees that bear no reasonable relationship to the landlord's actual damages. Landlords should set fee amounts that reflect their realistic re-rental costs and expected vacancy periods. Military members have the right to break a lease under the Federal Service Members' Civil Relief Act. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Pennsylvania's military population is moderate. Carlisle Barracks, home to the Army War College, generates some rental demand in the Carlisle area. The former military installations in the Philadelphia area have been redeveloped. The Pennsylvania National Guard and various reserve units generate some demand. Landlords near any active military facility should understand SCRA procedures. Pennsylvania has enacted protections for victims of domestic violence, sexual assault, and stalking that allow early lease termination. Under Pennsylvania's Protection from Abuse Act, Title 23, Chapter 61, and related provisions, tenants who are victims of domestic violence have certain rights that interact with their lease obligations. Pennsylvania enacted specific lease-breaking protections under Act 200 of 2014, which amended the Landlord and Tenant Act. Under this provision, a tenant who is a victim of domestic violence, sexual assault, or stalking can provide written notice to the landlord along with qualifying documentation, which can include a protection from abuse order, a court order, or a written verification from a qualified service provider or law enforcement officer. The tenant must provide reasonable notice. The specific requirements should be reviewed for current statutory language. When a qualifying tenant terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for the full remaining lease term. The landlord cannot charge an early termination fee based solely on the domestic violence termination. The security deposit is handled according to standard rules. Tenants in Pennsylvania may break a lease if the landlord fails to maintain habitable conditions. Pennsylvania recognizes an implied warranty of habitability in residential leases, established through case law. The landlord has a duty to maintain the premises in a condition fit for human habitation, including compliance with applicable building and housing codes. If the landlord fails to address serious habitability issues after receiving proper written notice and a reasonable opportunity to repair, the tenant may terminate the lease. The tenant should provide written notice identifying the specific deficiencies, allow a reasonable time for the landlord to make repairs, and document the conditions with photographs and written records. Pennsylvania's building code enforcement varies by municipality. In Philadelphia, the Department of Licenses and Inspections actively enforces the housing code and can inspect properties and order corrections. In Pittsburgh, the Bureau of Building Inspection handles enforcement. In smaller communities, enforcement may be handled by local code officials or the county. An official inspection and citation strengthens the tenant's position when terminating based on habitability. Pennsylvania also recognizes constructive eviction. If the landlord's failure to maintain the property or the landlord's affirmative conduct, shutting off utilities, changing locks, removing windows or doors, renders the property uninhabitable, the tenant can treat the lease as constructively terminated and vacate without liability for remaining rent. Philadelphia adds significant complexity to the breaking lease framework. Philadelphia's local ordinances provide broader tenant protections than state law, and landlords in Philadelphia must comply with both the state framework and the city's requirements. Philadelphia's tenant protections include provisions regarding lease terms, notice requirements, and the handling of security deposits that may affect how broken leases are processed. Philadelphia also has rent-controlled units, though the number is small. For any rent-controlled units, the interaction between rent control provisions and re-rental after a broken lease requires careful attention. Pittsburgh has also enacted local tenant protections that may affect breaking lease procedures. Landlords in Pittsburgh should verify current local requirements. From a practical standpoint, Pennsylvania has a large and diverse rental market with dramatic variation between its major metros and the rest of the state. Philadelphia is the state's largest rental market. When a tenant breaks a lease in Philadelphia, re-rental times vary by neighborhood. Center City, University City, Northern Liberties, Fishtown, and the Graduate Hospital area have strong demand. Landlords can typically re-rent within 2 to 4 weeks. Germantown, West Philadelphia outside University City, and North Philadelphia have more moderate demand with longer re-rental times. Philadelphia's student population is enormous. Penn, Drexel, Temple, Jefferson, and numerous other institutions create massive demand. Student lease breaks timed to the academic calendar, spring and summer, fill quickly. Mid-year breaks take longer. The Philadelphia suburbs, Montgomery County, Delaware County, Chester County, and Bucks County have strong markets driven by corporate employment and excellent school systems. Re-rental in the suburbs is generally quick for well-maintained properties. Pittsburgh has a strong and growing market driven by healthcare. UPMC is one of the state's largest employers, technology and higher education. The revitalization of neighborhoods like Lawrenceville, East Liberty, and Shadyside has created strong demand. Re-rental in Pittsburgh's desirable neighborhoods is typically quick. State College, home to Penn State, has a massive student market. The lease cycle revolves around the academic calendar, and breaking a lease during the spring or summer means quick re-rental. Mid-year breaks are significantly harder to fill. Allentown, Bethlehem, and the Lehigh Valley have growing markets driven by logistics and proximity to both Philadelphia and New York. Reading, Scranton, Wilkes-Barre, and Erie have more affordable markets with varying demand. Lancaster has a unique and growing market driven by tourism, healthcare, and a revitalized downtown. Harrisburg, the state capital, has a stable, government-driven market. York, Chambersburg, and other central Pennsylvania communities have moderate markets. One best practice for Pennsylvania landlords: determine whether your property is in Philadelphia, Pittsburgh, or another municipality with local tenant protections that affect breaking lease procedures. Build your processes around the most restrictive requirements that apply. If you own properties in both Philadelphia and a suburban county, your procedures may need to differ by location. Another best practice: document your mitigation efforts thoroughly whenever a tenant breaks a lease. Pennsylvania's mitigation duty is case law-based, and courts evaluate reasonableness on the facts. Keep records of listing dates, advertising channels, inquiry counts, showing dates, costs incurred, and when you accepted a replacement tenant. Your documentation demonstrates that you acted reasonably and establishes the departing tenant's actual liability. A third best practice: include a reasonable early termination clause in your lease that accounts for the local market. In Philadelphia's competitive neighborhoods where you can re-rent in 2 weeks, a fee of 1 month's rent with 30 days' notice is appropriate. In a slower market where re-rental takes 6 to 8 weeks, a fee of 2 months' rent is more defensible. Calibrate the fee to your realistic expected vacancy and re-rental costs. Pennsylvania requires landlords to return the security deposit within 30 days of the tenant vacating. The deposit is limited to 2 months' rent for the first year of the tenancy and 1 month's rent after the first year. The deposit must be held in an escrow account at a federally or state-regulated institution, and the landlord must provide the tenant with the account information. The landlord must provide an itemized list of any deductions. If the landlord fails to return the deposit within 30 days, the landlord may forfeit the right to retain any portion and may be liable for double the amount wrongfully withheld. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Pennsylvania breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.